as elections are around the corner in the United States of America, for former President Donald Trump, it seems like trouble continues to mount. This time around, we're looking at fresh inclusion and amendments to the indictment in the case of the insurrection. To discuss what that really means for the former president and the Republican presidential candidate, as also the other cases that we are looking at where there could be indictment or prosecution or ruling in terms of sentencing on the 17th. We'll discuss all that and more with Professor James Sample. He is a professor of law and has joined us before as well. So Professor Sample, thank you so much for joining us here on India Today Global. Let's begin with why the amendments. We've been looking at all the details of the case, trying to understand what's really happening. Is there politics involved in this, or are we looking at real strong reasons why there have been amendments made to the indictment in the insurrection case of January 6th?
Well, it's great always to be with you again, Geeta, and it's a very good question. I think that anytime you're talking about a prosecution of a former president who's also the nominee of one of the two major parties, politics can't be entirely separated from any aspect of the process. But Jack Smith, who is the special prosecutor who's handling the prosecutions both of the classified documents case and of the insurrection and election interference case related to January 6th in 2021, he is the special prosecutor. And this act of amending the indictment, a so-called superseding indictment, which is just a fancy phrase for a replacement, an additional indictment in place of the earlier one. It is mostly a legal decision rather than a political decision. And what he's doing is he's replaced the initial indictment with this new indictment because the Supreme Court on July 1 ruled that the president, or the former president in this instance, was immune from from prosecution for certain activity. And so he's had to circumscribe, he being Jack Smith, circumscribe and cut out some of the material that was in the initial indictment. What we have now is a more focused indictment of the president, the former president, but it does remove some of the key evidence that would have been useful to this prosecution if Mr. Trump were to actually face a trial in the January 6th insurrection case.
So amendment that leads to dilution, is that correct?
It's not. It's a good question. It's not clear that it is dilution. The same four charges that were brought in the initial indictment are in this indictment, and by those charges include things like the obstruction of an official proceeding. They include things like conspiracy to defraud the voters of their vote. And so the same core charges exist, but certain aspects of the cast of characters in the indictment. For example, the former president's conversations with his then vice president, Mike Pence, leading up to January 6th are no longer in the indictment, nor are the conversations that the former president had with the Department of Justice officials. In fact, Jeffrey Clark, who's one of the central players in this overall scheme to overturn the fair results of the 2020 election, is no longer mentioned in the indictment because he was at the Department of Justice, and the former president, as president, has as one of the presidential responsibilities communication with government officials. So what the prosecutors have done is they have augmented the indictment with all sorts of evidence about the conversations that Mr. Trump had with private, non-governmental officials. And what they're doing is they're emphasizing that he was acting not as president, but as a self-interested candidate. And the key point of emphasis from the prosecution standpoint in response to what the Supreme Court said is that a lot of what Mr. Trump was doing was not presidential. He has no role to play in certifying the results of an election. It was in his capacity as a self-interested candidate, not as a president acting on behalf of the American people.
Well, that's very, very interesting, Professor. But then again, in terms of process, the fact that it's more focused, the fact that the amendments have changed a lot of things and are now aligned with what the Supreme Court ruling really was, What does this mean for the process itself? Will that be will the pace of this indictment and the judicial process really be faster now, or will it take its own course and let the elections of the November 5th follow through before we can actually see some ruling on this matter? Because we'll go to the other one, which is on the 17th of September. But on this case, do you think it'll be after the 5th of November, or is a focused, more amended indictment really going to take it through to sentencing or trial or whatever that may be before the 5th of November?
Really good question. And Geeta, I think that the answer is next week, Judge Chutkan, who is the trial court judge in the January 6th case, is holding a hearing, and she's going to decide how she wishes to proceed with respect to the very, very difficult task that the Supreme Court has handed to her, and that's figuring out every single granular piece of evidence in the indictment or allegations in the indictment, whether it qualifies as immune from prosecution or not immune, in which case it can be part of a case. There is no chance, I think, unfortunately, there's no chance that this will be tried in any meaningful way prior to the election in November. But if Judge Chutkan chooses to have what it would be known as a pre-trial evidentiary hearing, that would be fairly damaging for Mr. Trump, because it would shift the focus from his campaign to what he did or didn't do in January of 2021 and in December of 2020. So this case will not be tried before the election, and that is really the biggest win that Mr. Trump has had. The same is true with the classified document. The two federal cases, as well as the Georgia case that he's facing, his strategy has not been to defend his conduct on the merits, but has rather been to delay. His real goal is to win the election, because if he wins the election, then as president, he will be in charge of the Department of Justice, the federal cases, and he will dismiss them. He'll drop them. It's a rare power that you have. And up until July 1, presidents never had this immunity before. This is a new development, and I would argue not a positive development for the United States in terms of the rule of law. But to be able to delay the process the way he has, to be able to carve out acts as immune even when he was breaking the law, and then potentially to be in a position to drop the case against yourself, that's a combination of powers that not many criminal defendants have in history have ever had.
Yes, and certainly not somebody who's on a presidential ticket. Having said that, we've done this before, Professor Sample, but for the benefit of our viewers, explain to us a few things, and I'll ask you to repeat yourself because you've answered these questions before. But before I come to that, the indictment and the immunity that you're talking about, what is the precedent that has been set with the immunity order, and how is it different from the past?
Really good question. So the president's lawyers argued in the federal context that the president was immune from prosecution because the president needs to be able to act in ways where the president is not being second-guessed or in fear of being second-guessed in the judicial process. The scope, and a lot of people, I think that at its base level, that's considered common sense. You know, if the president orders military action and it doesn't go as initially planned or desired, the idea of facing prosecution for that would lead to some very, very difficult things. On the other hand, if the president acts in ways that are contrary to laws that in theory apply to everyone, I mean, one of the most fundamental principles of what I would call a rule of law system is that no one is ultimately above the law. The United States fought a revolution against England in part because England took the position that a king can do no wrong. And so now in July, the Supreme Court decided that the president's core official actions and that even evidence about things that the president did, conversations with other governmental officials, can't be used because the president is immune from prosecution. To put that in a historical perspective, it takes a little bit of knowledge of American history, but many are familiar with Richard Nixon and the so-called Watergate scandal. Richard Nixon famously, engaged in a crime and a cover-up of a crime, and there were tapes, audio tapes in the Oval Office of him discussing the crimes that he'd committed. He argued that he was immune and that because he was the president, those tapes couldn't be part of a criminal prosecution against him. He lost. That was 50 years ago this summer. To say that in 50 years we've gone from a situation in which Richard Nixon was held accountable and ultimately had to resign to a situation in which Donald Trump has not only not been held accountable, but is now the leading candidate of one of two major parties to be re-elected and never having had to face real accountability for his actions, maybe because he's now immune in the terms of the Supreme Court, is not a great statement about the change in direction with respect to the rule of law applying even to the president.
Thank you for that long explanation, because I suppose our viewers needed to understand this. Because then to my next question, last time around when we were discussing, it was all about the trial. It was all about whether he'll be sentenced or not. Now, should he be, coming to the next part of the troubles that you see, the legal troubles that Donald Trump is right now in, the Stormy Daniels case, there is sentencing on the 17th. What happens then? Can a presidential candidate continue campaigning and run for president of the United States of America? And should he be sentenced, can he then serve as president?
It's rare that we have definitive answers in this realm, but in this instance, we do have two definitive answers to each of your questions. Can he still run even if he is sentenced? Even if he's sentenced, which I don't believe he will, but even if he's sentenced to incarceration, he can still run for president. He can still be elected president. And though the practicalities would be rather unimaginable, he could still serve as president, even if incarcerated. All that being said, I think that the real question with respect to the Stormy Daniels sentencing, now he's been convicted, the president has been convicted on 34 felony counts in that case. And in the rule of law, when you're convicted of 34 felony counts, you can't put off sentencing forever. However, the fact that the process has now been pushed to mid-September at a minimum, and the judge still has discretion to push that even beyond the election if the judge chooses to do so, it does raise some very, very delicate and difficult questions. To be fair to Mr. Trump, he is, at least with respect to the charges he was convicted of, these are non-violent offenses. He's a first-time offender on these bases, at least. Even in a typical prosecution of this nature, not against a former president, I think incarceration is relatively unlikely. However, no consequences at all is not really an option either. So the judge in that case, and facing the sentencing process, is an extraordinarily delicate situation. What do you do when you have someone who is simultaneously convicted and needing to be sentenced for 34 felony counts, and that person is not only a former president, but one of the two key competitors in the ongoing and upcoming presidential election? I don't know, if I were a judge, how I would handle it. I know that the American voters have an opportunity to ensure that Mr. Trump faces some measure of accountability if he loses the election. But if he wins the election, the question is really out there. Will he ever face any consequences, not only for the cases that aren't going to be tried at all if he wins, but even for the case in which he's already been convicted?
Well, again, very interesting. Also, if he is he's already convicted, if he's sentenced, whatever the sentencing might be, can he then, after winning elections, have a retrospective decision of invoking immunity or dismissing the case completely? Is that possible, or legally that's not possible?
So in the
He will have
case
to
of the
serve.
Yeah, really good question. In the case of the Stormy Daniels case instance and the convictions in the Stormy Daniels case, what is unique there relative to the other charges he is facing is that that is a New York State case, and United States law is such that the presidential pardon power, so he's convicted, the pardon power to essentially do away with convictions only applies to federal offenses. The president couldn't pardon any state defendant, much less pardon himself of state charges. So the fact that it's a New York State case is very helpful for the pro-accountability crowd and very unhelpful for Mr. Trump. And the other aspect of this is that the activities at issue in that case, by and large, took place before he was the president. So certainly whatever liaisons he did or didn't have with Ms. Daniels, the arrangement to come up with the payment scheme. Now, he did continue to make payments while he was in the Oval Office, but I think it would be extraordinarily difficult, even for this rather extreme Supreme Court, which is very much in his favor as a general matter, to argue that paying your mistress just because you were in the Oval Office when you signed the checks constitutes official presidential activity that should be immune. I don't foresee that as being an issue. And so in some ways, the Stormy Daniels case is, in a sense, the least important of the four cases that he was facing, but it might well end up being the case that the least important, if you want to use that as an adjective, ends up being the one that actually involves actual consequences.
Okay, Professor Sample, just zooming out a little and the elections, how do you see these cases impact his campaign? The positives of it, the fact that he could confine it to no sentencing or trial before November 5th, but also the fact that there is a sentencing in another case, maybe the magnitude of the offense is not as high as the other cases. But what are the positives, the advantages that he's taken in the realm of the trouble that he's in, and the disadvantages at this point in time?
Yeah, it's an amazing thing. You would think in a rational universe that being a criminal defendant in four cases and also having already had multiple civil judgments against you, including for very serious matters like sexual assault in the civil context involving E. Jean Carroll. I mean, some extraordinarily consequential and serious charges at the criminal level and also at the civil level, including fraud at the civil level where he's facing a massive judgment. In any rational world, those would be disqualifying for a candidate, and at the very least would be, if the candidate weren't formally disqualified, would seem to render the candidate unpalatable as a viable election option. In this scenario, the more Mr. Trump is prosecuted, in some respects, the more dug in his defenders and supporters become, the more intensely they support him. And you can theorize whether that makes this less a political party and more of a cult, or more of a cult of, or whether the political party has really become all about one man as opposed to about policy or about the vision for America. But for whatever reason, Mr. Trump has proven to be politically able to endure charge after charge and case after case. And in some ways, he's been able to make himself a martyr, if you will, and claim that he's being persecuted unfairly, even though to invent all of these charges in all of these different jurisdictions as if they didn't happen. I mean, you couldn't come up with a conspiracy if these facts weren't at least in significant part quite real. So what does it mean in terms of the next 2 months before the election? Really, really hard to say. I think that in many respects, the cases which were at the fore of our focus earlier in the summer have kind of taken a back seat as Kamala Harris has become the Democratic Party nominee, and that's been the new focus, right? Biden stepping aside, Harris and Walz now being the opponent, and I think that the focus has been very much shifted. over the next couple of months, the focus, I think, is going to be divided because, as you note, Gita, there are going to be developments in these cases, the sentencing, potentially an evidentiary hearing, potentially rulings from Judge Chutkan on a preliminary basis in the insurrection matter. So Mr. Trump will be the focus of some unhelpful attention, and yet I say that at the same time, unhelpful attention seems to, in some perverse way, end up being helpful for him. So it's hard to predict.
Absolutely, because he turns it around and he calls it political vendetta.
Yeah.
And he is going to turn it around and call it political vendetta. Having said that, like you said, Professor Sample, that this is not going to impact his presidency per se, should he win, or the campaign. But yes, it is going to become a political issue all through the campaign and might affect the debates as well. Thank you so much for joining us and explaining in detail what this really means. But before I let you go, just a final word on the indictment itself. We are seeing an amended version, but will a focused indictment really impact the campaigns negatively, or like you just said, he's just going to use it as political vendetta and carry on? What's really going to happen over here?
I think that it should impact the campaign, but I think it's unlikely that Americans at this point are really paying close enough attention to the details of the indictment. I think that the personalities of the two candidates, in theory, the policy differences of the two candidates, although this has not been a policy-driven campaign, it's been a personality-driven campaign. I don't know that the indictment will end up playing a significant role over the next 2 months. That being said, that could change if, for example, Judge Chutkan chooses to have pretrial evidentiary hearings, which would put a spotlight on the activities at issue. And that would be, I think, even apart from the case, unfavorable for him politically.
Right. But will not change his fate should he win the elections, will not change anything in terms of being on the Republican presidential ticket. Have I got that right?
Exactly right, as always, Gita.
Professor Sample, thank you so much for joining us. That's Professor James Sample from Hofstra Law School, joining us to explain to us what's really happening in the United States of America. How much of a trouble is Donald Trump really in, and will that impact his presidential run as also? Should he win the presidency, will he continue or will he be able to run the country as president? Thank you so much for joining us over here on India Today.
Thank you.